In a packed courtroom, Lori Vallow's first appearance back in Idaho, speaking barely above a whisper.
Yes.
As many in the town of Rexburg demanded to know where are 7-year-old JJ and 17-year-old Tyler.
Hello and welcome to True Crime Rocket Science, the most authentic voice in true crime. You just heard Lori Vallow in court there just saying one word, yes, and that was on the 7th of March 2020, more than a year ago. That was during her first court appearance. So the question comes up, has Rob Wood caved to Lori Vallow's defense? Has the prosecutor given in? No, I don't think so. I don't think Rob Wood has caved in. He's probably found the evaluation has merit and realized he simply has to wait for the quote-unquote restorative treatment to take its course. This unfortunately puts the ball somewhat in the defense's court now, meaning the trial will likely proceed when it suits them. Now, interesting in this article, and I'll put a link to it in the description from East Idaho News, the article says, prosecutor no longer disputes the competency of Lori Vallow Daybell. What's interesting in the article is what I suspected all along. It's not rocket science, it's certainly not a big stretch to have imagined this, but I did suspect that it was the defense that requested the competency hearing in the first place, and they requested it in March. And so this is a quote from the East Idaho News pertinent to that particular part. Quote, Mark Means, Daybell's defense attorney, requested a psychological evaluation for his client in March. A licensed clinical psychologist met with Lori Vallow in the Madison County Jail on at least 2 days, and according to court documents filed last month, determined the defendant, as Lori Vallow, was not competent to proceed. Restorative treatment was recommended. It goes on to say, while District Judge Stephen Boyce put a stay on the case, he still needs to legally declare Daybell is unfit for trial, end quote. And I think that's quite important to stress, is that although the psychological evaluation happened in March, we're now in the middle of June, and the judge still needs to legally declare, he's going to make it official, that Lori's unfit for trial. What I find extraordinary is that Lori has been in custody for well over a year, and so applying for a competency evaluation just as the trial is gaining a little momentum, it feels more than a tad mischievous by the defense. I mean, we remember Lori Vallow being in court in March 2020. You know, it's well over a year since then. Why was it not raised then? And we do know that she's had changed legal counsel since then, but it does seem very late in the day to be putting your hand up now going, oh, now that I've been charged with murder, well, now I'm not really going to, I'm not sure if I'm really competent to stand trial. Now, to be fair, and I think one's got to be fair, is the competency thing came up in March, and I don't know whether they've only released the results of the competency thing in March, but the issue dealing with the murder charges, they came out in May, towards the end of May. And so I think that aspect is definitely quite interesting. It seems peculiar that she's been in and out of court for over a year, as I say, before even her own defense counsel deemed it prudent to have her competency checked out. I mean, if she wasn't competent, you'd imagine that her own lawyer would have picked that up right in the beginning. I mean, if her lawyer personally felt, well, you know, I don't think you're competent to stand trial, I think it's a separate question to say the court may find you not competent, if that makes sense, right? And so what's likely to happen now, the answer to the question posed here, you know, what's going to happen next? Well, we are likely to see a series of delays. There may be 3 months, it could be 6 months or even longer as Lori receives treatment and either regains competency, and that's quite important to stress. She can regain competency where she gets restorative treatment. She's then evaluated again, and or there's just an assessment that she is now competent to stand trial. But it's also possible that she doesn't. And I think this is the downside of having the defendants tried together. Who knows, the defense might be using this as a bargaining trick to tempt the prosecution into asking that Chad be tried separately. And that would certainly favor the defense. Now, I want to stress that the preliminary hearing was for Chad. Remember I think it was August, there was a preliminary hearing where Melanie Gibb testified. And that happened, I think, around about the 8th of August last year. I'm not 100% sure if there's been a preliminary hearing for Lori. And I say that because about 10 months ago, Lori appeared in court and she waived her right to a preliminary hearing. So what could be the case is that in the sort of muddiness of the legal process, you sort of had a situation where she waives her preliminary hearing and then Chad didn't. And sort of in the interim, they're now going to be tried together. And so effectively, Chad's preliminary hearing perhaps becomes theirs or not. I don't know. It's quite difficult to see it that way. In any event, she's not having a preliminary hearing, but we do now need to get some clarity on, what is going to be the situation with regard to them being tried together. There's already been quite a weird narrative, a legal narrative that has been going on, with this particular case. We've had the judge removing himself from the case. That was a year ago. And then also Lori Vallow's attorney at the same time, withdrawing.
I'm erring on the side of caution and on the side of defendants' rights to disqualify without cause. So with that will negate the need to hear further argument today on Mr. Means' motion on behalf of his client to disqualify me for cause. A new judge will be assigned to this case at the magistrate level. We'll set this for the preliminary hearing. I'm going to sign that order that continues the preliminary hearing for the 7th and the 8th. I don't believe there's anything else that we need to take up today. Mr. Wood, do you have any questions about my ruling?
No, thank you, Your Honor.
So you just heard Judge Farron Eddins there basically writing himself out of the trial narrative. This was way back in, I think it was March 2020, just before the preliminary hearing was supposed to happen. He approved the preliminary hearing to be held on May 7th and 8th instead of the previously scheduled March 18th and 19th at the Madison County Courthouse. At the same hearing, the former defense attorney for Lori Vallow, Brian Webb, also withdrew as one of Lori's attorneys. And then there was also Edwina Alcox, also working under Webb's law firm, who was also scheduled to withdraw at that point. So just in terms of the legal narrative, there's been a lot of intrigue, hasn't there? So I think it's quite a fascinating thing to ponder, has this been done on purpose in order for the defense to try and wrest some kind of control over the legal side of the narrative? For example, do they want a situation where they don't want the defendants tried together? Because I do think that very much favors the prosecution. There are many areas where Chad could simply say, I wouldn't know about that, you'd have to ask Lori. And of course, if they're not tried together, you could have that happening constantly. So who knows? It could be a bargaining trick. On the flip side, the treasure from Chad's property can only go so far. So the longer they delay and postpone before the case goes to trial, the sooner Chad won't even be able to afford the likes of John Pryor. He won't be able to afford his defense. For those interested in this case, those who are really enjoying the coverage of Lori Vallow and Chad Daybell, I'll be putting up episode 15 of the Lori Vallow and the Missing Children series, which comes up every Wednesday on Patreon. I'll be putting that up on Patreon a little bit later today. That's on the $3 tier. Once again, if you haven't subscribed, please do like, share, leave a comment, and I'll see you guys next time.